Hello friends, today we are going to study about fundamental rights. Fundamental rights is mentioned in part 3 of our constitution, Article 12. So Article 12 says about definition of state. Why it is important to define state? Because state has an enormous power and it has capability to curtail right of an individual. So there need to be a clear idea of what state constitute. So let us get started. First, it constitutes center. Center means central legislature and central executive. State, that is state legislature and state executive. Third, local authorities. Fourth, statutory authorities. Fifth, other authorities. Now, statutory authorities are the ones which are established by the law of the land, and other authorities, likely private authorities, also comes under the purview of state under two conditions: if it acts as an instrument of government, that is it performs some sort of government duties on behalf of government, or it does some sort of important public functions. Now when it comes to judiciary, we can distinguish judiciary's function into two types: administrative and judicial. So for judicial function, it is not coming under the purview of Article 12, but this administrative function is coming under the purview of Article 12. And one more information is that UN does not come under the Article 12 states definition. Okay, got it. Then comes Article 30. Article 30 states that law which are inconsistent with the fundamental rights shall be null and void. So basically laws are of three types: permanent, temporary and statutory instruments. So permanent laws are legislations by center, by union parliament and state legislature. Temporary laws are ordinances which is promulgated by the president or the governor of the respective state. Now statutory instruments are delegated legislations performed by executives. So what do you mean by delegated legislations? So in a legislation, if a bill is passed, certain portion of the bill can be legislated by the executive. So it is called delegated legislation. Now another is bylaws. Now what do you mean by bylaws? Bylaws is associated with a corporation or 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 association. Then other is customs. So customs of a society also can be under the purview of law. Okay, if any of these law is in contravention with the fundamental right, it shall be null and void. Now coming to the first fundamental rights, before that we can go through the easy categorization of fundamental right. Right to equality from Article 14 to 18, right to freedom from Article 19 to 22, right against exploitation from Article 23 to 24, right to freedom of religion from Article 25 to 28, cultural and educational rights Article 29 to 30, and lastly right to constitutional remedies Article 32. So let's get started with Article 14 of the Constitution. So Article 14 of the Constitution says about equality before law and equal protection of law. This is a British concept, whereas this is a US concept. Equality before law means that there is no special privileges for any people. There is no special privileges for any people. Okay, special privileges is not there. Instead, everyone is equal before law. Whereas equal protection of law means that everybody, or there will be equality in treatment for those who are equally situated. Okay, equal treatment under equal circumstances. Okay, this is what we call equality, equal protection of law. And this equality before law is negative in nature, whereas this is in positive in nature. Okay, I hope you got it. Now, coming to these exceptions. So exceptions of this Article 14 is that for presidents and the governors during the term of office, no criminal proceedings can be taken. But in case of civil proceedings, 2 month prior notice should be given. 2 month prior notice should be given. Then a person who reports true events of the proceedings of parliament is also immune to Article 14. MPs and MLAs, whatever they say in the parliament, okay, or whatever stance they take in parliament and vote is not questioned in the court of law. Okay, that is also covering under the exceptions. Then sovereigns, foreign sovereigns, ambassador, diplomats also enjoy some sort of immunities, okay, in India from criminal and civil proceedings. So these are some of the exceptions which is being granted to some people during some circumstances. Otherwise, everyone is equal before law, and equal protection of law is being guaranteed to the citizens of India. Now coming to Article 15. Article 15 says prohibition of discrimination. Prohibition of discrimination. There would not be discrimination, or citizens won't be discriminated on the basis of religion, race, caste, sex, or place of birth. And discrimination based on other grounds is permitted. Okay. Now, if a public amenities is being constructed and it's being delivered to the people, that public amenities also shall not be discriminating a person based on religion, race, caste, sex, etc. Okay, this Article 15 is not only directed against the state, it can also be directed against the private. Because why? Public amenities can be created by the private individuals also, rather than government. So for example is that public well, it's a public amenity, it can be used by any people. Public schools, it can be used by any people. If any of the persons are discriminated based on their caste, it is violation of Article 15 of the Constitution. Now certain exceptions are being there, that is special provision can be made for the upliftment of children and women according to 15 clause 3. Then affirmative actions is guaranteed for socially and educationally backward classes, or SC/ST, okay, in general. SC/ST and socially and educationally backward class. Then 15 clause 5 says that these SC/ST, socially educationally backward class, will have reservation in educational institutions, and by 103rd at Constitution Amendment Act, okay, the reservation policy is also being extended to educationally weaker section in general category. Now coming to equality of equal opportunities in public employment. Okay, So this is Article 16 of the Constitution. Now there are some exceptions also. This that in Andhra Pradesh and Telangana, in some fields, only their natives are allowed to occupy that jobs, and it is being prescribed by the Honorable Parliament of India, and Parliament can do so. Such exceptions are allowed, but in many cases there is equal opportunities for every Indian citizen, and they can't be discriminated based on race, caste, sex, or place of birth. Okay. Now backward classes. Okay, now in the pretext of Article 16 only we are going to learn this backward classes. So first backward class under the chairmanship of Kaka Kalekar. Kaka Kalekar. Kaka Kalekar was constituted in 1953, and it submitted its report in 1955. It has identified some backward classes, but the report was not being implemented, and in 1979 second backward class commission was being constituted under the under the chairmanship of Mandal. This is also famously called Mandal Commission. Now Mandal Commission has identified some of the socially and educationally backward classes, which is OBCs. Okay, OBCs, they constitute more than 50 percentage of the population, more than 50 percentage of the population, more than 50 percentage of the population. They constitute more than 50 percentage of the population. So according, one of the recommendation of Mandal Commission was that 27 percentage reservation must be there for the people of OBC in public employment. Okay, this created chaos in our country because many of the OBCs have supported it, and some of the people opposed it, claiming that it would trouble merit system, and OBC says that it is kind of an affirmative action and for their upliftment. So in 1919 this Mandal Commission report was implemented by VP Singh government, and it created a kind of a chaotic situation in the country. So to cool this down, Narasimha Rao government in 1991 or 1992, okay, I am not sure about the date, Narasimha Rao government had proposed two solutions. Okay, two solutions to it. That is, 27 percentage reservation will be maintained. In addition to that, 10 percentage reservation will be extended to EWS. But during the Mandal case of 1992, okay, Indira Sahani versus Union of India case 1992, Supreme Court has struck down this second provision and said that 27 percentage of reservation is being retained, is justified for the OBCs. But Supreme Court has put forward some sort of conditions for that. What was that? Creamy layer, the concept of creamy layer, that is, well-off section of the OBC people should not benefit from this reservation. Then reservation is only limited to the appointment, not in the promotion. And third condition was that it should not exceed 50 percentage, that is, in the overall appointments, reservation should not exceed 50 percentage, even with the carry forward rule. Okay, now in 1993 Ram Nandan committee was constituted by the central government for inclusion, for checking into under inclusion, over inclusion, inclusion of backward communities. Now for checking these aspects like under inclusion, over inclusion, and welfare of OBC communities, National Commission for backward class was being created in 1993. Okay, and by 102nd Constitution Amendment Act, it became a constitutional body, and Article 338B was inserted into our constitution. Now, 77th Constitution Amendment Act created reservation in promotion for SC and ST. 85th Constitutional Amendment Act created the doctrine of consequential seniority. That means if an SC and general employee is there, okay, so according to normal seniority, if that general candidate would get promotion early, but due to consequential seniority, what happens is that the SC community will get promotion over general community, general person early. So this is the concept of consequential seniority. Okay, now this is consequential seniority was being introduced by 85th Constitution Amendment Act. Now, this reservation in promotion had some sort of limitations imposed by the as imposed some conditions by the Supreme Court. Okay, what were the conditions for the reservation in promotion for SC STs? There must be quantifiable data. There must be a quantifiable data that SC ST community doesn't represented in higher levels of position. Okay, there must be quantifiable data. Now, what happens is that that of inadequate representation, and secondly, it should not affect the administrative efficiency of the department. So by meeting these criteria, what happens is that the government can go with reservation in promotion for SC and ST community. Now, not that this Honorable Supreme Court has held that reservation is not a fundamental right. Now, moving to Article 17 of the Constitution. Article 17 of the Constitution prohibits untouchability. Now, untouchability is a social disability based on birth. Now, many of the acts are being enacted in order to criminalize this untouchability act. One such act is SC/ST Prevention of Atrocity Acts. So, this act is only applicable when a non-SC or non-ST person commits a crime against SC or ST person, and it can also be directed against uh, a government officials. Okay, government official who show negligence towards duty of SC/ST. Now it can also deny it can also deny the anticipatory bail if you have been charged with SC/ST Prevention of Atrocity Act 1989, and there will be also denial of probation to convict. Probation means that if a convict is seen as a good mannered fellow for some period of time, he would give a probation, that is he would be set free. Okay, but it won't be applicable to these people. Okay, special courts and special prosecutors will be constituted, and there will be identification of atrocity prone areas also. Okay, where the SC/ST communities could get hurt. Now, Article 80 of the Constitution speaks about abolition of titles. So, but some exception is there. Academic and military achievements can be regarded as our titles, because I can say that I am MA Fahim, MA psychology, like that I can put it on my name board, etc. Or military achievement, the British Brigadier Ram Singh, etc. They can keep with them. That are exceptions. But what are the titles that some sort of Raja, Nawab, that we should not call? Every citizens are equal, and even Padma Shri also. Okay, ideally we must not call a person Padma Shri such and such names. Okay, ideally, so such kind of restrictions are being there in order to promote equality. Then citizens can't accept a foreign title and foreign title, okay, from a foreign country. Okay, then what about foreigners? Foreigners who hold office of profit, can they accept foreign titles? They can only accept foreign titles with the president's permission. Okay. Next, coming to one of the star uh, freedom fundamental right, that is Article 19, that is the right to freedom. So it includes freedom of speech and expression, freedom to form association and freedom to form association, freedom to movement, freedom to reside. Okay, then freedom of profession. So speech and expression, what happens is that we are free to express our thought and express it. Freedom of association, we can form many associations, political party, etc. Political parties, pressure groups, or any sort of education, any sort of associations. But some restrictions are there for these rights. Why? These restrictions are based on few criteria, that is, if it affects security of our country. Okay, only thing, it can be restricted based on the security of country. Now if it defames a person, it can, we can restrict these rights. Okay, then if it affects friendly relation with another country, with other country, it can also, we can also think. So these factors, some of these factors restrict freedom of speech and freedom of association. Okay, then another is also there, public order. Okay, these are some of the factors which is providing restrictions to freedom of speech and freedom of expression. Okay, now coming to movement, so we can move freely as an Indian citizen. Internal movement is granted, sorry, is being given by this Article 19. We can move anywhere in the country, we are free to move. But in the areas of schedule 5 and schedule 5 and schedule 6, there are restrictions because these are tribal areas. We are not allowed to go to that places without authorization. Okay, such restrictions are being there, and external movement is being covered under Article 21, which we will discuss later. Now we have freedom to reside in any places. Okay, but there are also restrictions to it, because SC has observed that the prostitutes and habitual offenders are not allowed to stay in a normal residential areas. They are being restricted. Okay, now, freedom of profession and freedom of trade is also being guaranteed by the constitutions. So these are some of the freedoms and restrictions being imposed by Article 19 of the constitutions. Then Article 20. Article 20 gives what? Protection. It gives protection to the convicts. So based on three areas: ex post facto, double jeopardy, and self incrimination. What do you mean ex post facto? That is, if you commit a crime, you will be punished according to the law prevailed during that time only. Okay. For example, I committed in 2006. If I assaulted a person, I would have an imprisonment of 4 years. But when it came to 2007, it was only 2 years. Now I committed a crime in 2007, but the court of law can't give punishment according to 2006. Okay, so it is called ex post facto. Now coming to, so this ex post facto is being applicable to criminal laws only, that is one of the crux of it. Now double jeopardy means what? A person can't be punished more than once for the offense committed. Okay, Now there are exceptions also there, that is in the departmental proceedings. Okay, in the departmental proceedings, this immunity is not enjoyed by the citizens, okay, or by any of the people, okay, any department. Only judicial proceedings only this double jeopardy is applicable. Now self incrimination, that is anyone can't bear or can't be forced to bear self witness against others, against oneself. So this is applicable only to criminal laws, okay, but there are exceptions. What were the exceptions? That you need to compulsorily produce material object if it is inquired by the investigative agency. Besides that, thumb impression, signature and blood should also be produced, okay, and this is only applicable to criminal laws. Now coming to article 21A. Article 21A is the right to elementary education, okay. So this was being inserted by 86th Constitution Amendment Act. In order to enforce this right to education act was being implemented in 2009. Moving down to Article 22, it is protection against unlawful arrest. Now the arrests are of two types in our country. Okay, the arrests are of two types in our country. So we will just look at it. Now arrests are of two types: punitive as well as punitive and preventive. Okay, punitive as well as preventive. Okay, punitive and preventive. So punitive detentions are in that detentions or in that arrest you are found guilty, whereas preventive detentions are being made in order to prevent you from committing a crime or a mistake. Okay. Now under an ordinary law, under an ordinary arrest, what happens is that a person must know on what grounds why he is arrested, okay, and he should have right to consult an attorney or a lawyer, okay, attorney or a lawyer. He must be produced in front of the magistrate within 24 hours after the arrest, and this magistrate, and within 24 hours, if magistrate does not extend his custody, he need to be released free. This is under the ordinary circumstances. But what about the preventive detention? Preventive detention, such circumstances no need. A person can be kept for 3 months in preventive detention. But if it is exceeding 3 months, if authority want to exceed it to beyond 3 months, an advisory board's recommendation is needed. An advisory board's recommendation is needed, which consists of judges of high court. And the parliament can make laws related to the appointment of advisory board or the manner in which the advisory board need to function. So this is all about protection against unlawful arrest and detention. Okay, next is Article 23, which says prohibition of traffic in human beings and forced labor. So this is held illegal in our country. Okay, Article 24 is talking about prohibition of child labor. So a child is who is below the age of 40, and they are not allowed to work in a hazardous environment. That is only being said in Article 24. They should not be allowed to work in a hazardous factory or hazardous environment. Okay, what if a boy who is under 14 works in an unhazardous environment? Okay, it will be not covered under article 24. Okay, now article 25 says about freedom of conscience. Freedom of conscience, that is right to practice, practice, profess and propagate religion. Okay, we can follow our religion, whatever religion you can want, we can practice it, we can profess it, we can propagate it, and this propagation should not be seen as right to convert. Right to convert, right to convert is not guaranteed under this law, and this law is subject to some sort of restrictions also. Okay, what are they? That is public order, morality and decency and health. For example, some of the religious practice, if it is detrimental to the health, state can come up and intervene in that practices. Now article 26 of the constitution says managing religious affairs by some sort of by religious denominations. Now, who are these religious denominations? They would have a common faith, they would have a common organization, and they would have a distinctive name. So this cannot be a religion, but it will be a subsect within a religion that will have a common faith, common organization, distinctive name. So these religious domination can manage, establish and manage an institution, acquire property that which is immovable or immovable, and it has a right to administer that property also. So these are some of the freedoms granted to article 26 of the constitution. Okay, okay, they can manage their affairs if they are in the article 29. Okay, article 26 of the constitution. Now moving to article 27. Article 27 of the constitution, that is its freedom to not fund for promotion of particular religion. So the government, if it is spending for the promotion of a particular religion, it is against article 27. Okay, because it is the public money which is being spent for it. Okay, now article 28 of the constitution. Okay, article 28 of the constitution is saying about freedom from abstaining from religious instruction. This is applicable to adult and minor also, and in case of minor, consent is coming from parent. Now religious instructions are being permitted in some institutes as well as not permitted in some institutes. Government schools totally banned. Religious instruction is banned in government institute totally. Now when it comes to aided, when it comes to permitted in aided school, they can voluntarily give religious instructions in recognized schools by the government also, and the schools which is administered by state but it was established by a trust or an endowment, religious instructions can be given, but the individual has the right to abstain from it. He should not be forced to listen to the religious instructions. Now coming to article 29, so this is giving protection of culture to certain sections of people. So this can be what, this is given to any of citizens of country who want to protect their distinctive culture, language, etc. Okay, Supreme Court has held that this right is being applicable to minority as well as majority, and in addition to it, this article 29 clause 2 says that no one will be discriminated by the government school or government aided school based on their culture or language or any other differences. Okay, Now coming to Article 13, that is right of minority to administer educational institutions. Type of minority institutions are, the first one is minority education, which is recognized and aided by the state. Second is recognized by the state. Okay. Third is which does not seek recognition or aid from the state. So these two type of minority institutions is subjected to government regulation in appointment, in determining the syllabus, etc. Third category is not under government regulation. Okay, but SC held that, but you can say that all these educational institutions are subjected to general law of the land, general law of the land. Okay, and it should not be seen as reverse discrimination mentioned by the Supreme Court. Reverse discrimination is a kind of affirmative action by which affirmative action given to a society because of the disabilities faced by them in the past times. Okay, so it should not be seen as a reverse discrimination. Okay, which is seen which is given to SC/ST communities. SC/ST community is a reverse discrimination because they have faced a kind of a social discrimination. Now, SC community, Supreme Court held that this fundamental right is not a license for maladministration, and the government can intervene in all the minority educational institute for their proper functioning. Okay, so this is not an absolute in nature. Article 30 is not absolute in nature. Generally, all the fundamental rights are not absolute in nature. They are subjected to reasonable restrictions. Okay. Now coming to the last, Article 32, that is right to constitutional remedies. Okay, right to constitutional remedies. Let me go to another page. Article 32, right to constitutional remedies. Okay, it states that if any of the fundamental rights is violated, a citizen or a person can approach the Honorable Supreme Court directly or High Court. There is no hindrance. One can directly approach Supreme Court. Okay, one can approach Supreme Court under Article 32 and High Court under Article 226. How these fundamental rights are enforced by the courts? Okay, by writs. What are the writs? Okay, first is habeas corpus. This has been issued against private as well as public authorities. That is, habeas corpus means to produce body. Okay, if anyone is illegally detained, he must be produced in the court of law. Okay, that is called habeas corpus. Then another is mandamus. Mandamus is being issued against the public authorities for their malfunctions. Prohibition. Prohibition means that if lower courts, it prevents lower courts from exceeding their powers by higher court. For example, if a high court found that a lower court is exceeding their powers, it will prevent it. So it is preventive in nature. Another is certiorari. Certiorari is preventive and curative in nature. that is the higher courts will prevent lower courts from crossing their power limits, and they will take up the case and cure the problem, that is the certiorari. Okay, resolve the problem, that is the certiorari. So with this I am stopping the presentation. Thank you and have a nice day.